Welcome to the Law News Docket, the part of the show where we review law-related stories in the news and how they affect us. It's a new year, and we'd like to start off this year by suggesting that if you have not taken care of estate planning in your family, you really need to make it part of your New Year's resolution. That's our focus today.
A recent survey from Alliance Insurance found that the focus on fitness over finances has been a recurring trend, reaching its point in 2014. 49% of respondents to a survey said that health and fitness was their most important focus area, up from 43% in 2013. And we'd like to offer that taking care of your finances is just as important.
You know, on average, more than 55% of the population will die without preparing a will. Among minorities, the numbers are higher than in the general population. 68% of black adults and 74% of Hispanic adults do not have a will.
Today, we would like to discuss some high-profile examples of estate planning and how to avoid some of the mistakes that many continue to make.
Joining us today is our special guest, Isaac Heintz, who we will interview a little bit later in the show. Isaac, if you can just introduce yourself and tell everybody a little bit about yourself.
Yeah, my name's Isaac Heintz. I've been a Cincinnati resident all of my life. I was born and raised in Clifton. My father, he was in the symphony for over 25 years, and that's what brought him here in the first place. I practice with the Finney Law Firm. I'm married and have 2 children, a daughter and a son. My daughter just started school, college, and my son is at Fairview.
All right, well, thank you. Let's talk a little bit about estate planning in the news. You know, we've seen several high-profile cases recently. That includes Philip Seymour Hoffman and Paul Walker, among others. You know, are there any mistakes that are going on among the celebrities?
Based on those 2 that you've just talked about, there were some holes in their estate planning. In Philip Seymour Hoffman's estate, it seemed like a big issue that he had was he only had a will in place when he probably could have used a trust, and probably he could have had some better advice on how to do some tax planning to avoid paying the estate taxes that his estate will end up having to pay. He is obviously a high net worth individual. The average person doesn't have to worry about some of the issues that he had to worry about. If you have under $5 million, there's probably not a concern, especially in Ohio where we have no estate tax, that you'll ever have to pay any estate tax. But with high net individuals like that, when you get on the federal top brackets, you're talking 40%, plus he's in New York and there was an additional New York tax on it too. So I think that they estimated that it would be over $10 million that the estate would end up having to pay in the long run.
And you think that a lot of that could have been avoided?
I think there's planning vehicles that could have been used even beyond just a simple will and trust, like family limited partnerships or limited liability companies, doing some annual gifting that's excluded from your estate. Those types of vehicles could have been used to help him avoid some of the taxes that he's facing. Another issue is not updating his estate plan. That was a concern. Apparently at the time he did it, he only had 1 son, and it left 2 of the children unmentioned within his estate plan. I'm assuming New York law is similar to Ohio law, and that they probably have a right to try to get a portion of the estate over to them, since they were not mentioned within his estate plan one way or another.
You know what I found interesting in looking through some of the information regarding the Hoffman estate is the fact that he indicated in his will that he wanted his son to be raised during certain times of the year in various cities. I believe one was San Francisco, so that he can enjoy the culture of that particular city. I found it interesting too that the author of this particular article talked about the fact that he could have also put in there that he wanted his children to be alcohol and drug free for them to get money out of his estate. Have you seen things like that in your practice?
Yeah, definitely. With incentive trusts, when you have young children or children that are the age of college, a lot of times the parents want to make sure that the assets go to them in a manner that's going to promote their best well-being. Especially with high net worth families, I think one of the unfortunate things that I've seen time and again is that you have beneficiaries of these trusts that are just entitled to things, and it really doesn't help them in the long run. When you tell a kid that they have millions of dollars, and they know that from the get-go, and they have no incentive to do anything, a lot of times the kids don't turn out well. That doesn't happen all the time, but I've seen it time and again, especially with trust beneficiaries of high net worth individuals. If they know they're going to be taken care of anyway, it does provide little incentive for them to actually take care of themselves. Now, I've seen it on the other extreme too, where you have a very successful parent decide that they don't want their kids to retire anytime soon, so they hold everything back until the child becomes 65, which I'm not sure that that really benefits anybody, but it's their stuff and it's their personal decisions to make.
So in a situation like that, they can require that their child finish college, finish their post-college education in order to end up getting anything out of the estate?
Yes, sir.
You know, one of the questions that I see, or that leads to a question, is some of the celebrities, when they pass, the assets are disclosed, and a lot more information comes out on one particular celebrity versus information that comes out that may be very limited on another celebrity. What is used to accomplish that?
Right. I think what you're talking about is a distinction between having a probate estate versus a non-probate estate. In most states, and I think there's certain exceptions, I think I've run into it in Pennsylvania where you actually have assets in a trust that can be disclosed, but in most states I think that trusts are private vehicles that should not come to light in the public forum. Now, if there's a case about it or something like that, then the assets can get disclosed and the terms of the trust can get disclosed if there's a dispute about the trust or the assets within it. But typically, for the average person doing estate planning, trusts are going to be private vehicles. So if the trusts are funded, or they're set up in a manner where your assets are transferred on death to your trust, where they're going to transfer by contract as opposed to through your probate estate. So a probate estate is assets that are in your individual name that don't go by contract or transfer on death designations to another individual. So the will tells you who's to take care of that, that's your executor, and where the assets will go.